All right, if council would please announce their names for the record.
Kofi Kennedy Swanson on behalf of the Office of the State Attorney.
And Manuel Soto Diaz with the Office of the Public Defender.
All right, thank you.
Your Honor, we also have Cody Jordan. with
Cody
my
Jordan
office.
for the Public Defender's Office as well.
All right, thank you. Now, the first case I have is that of Corey Stanley.
Corey Stanley refused, Your Honor.
All right, let's see. All right, apparently this occurred yesterday also. So, in an abundance of caution, your name, sir?
Scotty Casino.
This is not Mr. Stanley, Your Honor.
Say again?
This is not Mr. Stanley.
Okay. All right, then the Office of the Public Defender would be appointed in regard to Mr. Stanley's case. And I don't have a division number.
19.
19. Division 19.
Are you gonna reset it for tomorrow?
Yeah,
Since they refused it?
let's reset again. All right, Scotty Calcino?
Yes.
Is that you, sir?
Yes.
All right, sir, you've got a case here involving criminal mischief. There was a warrant issued, the bond set at $2,500. Do you want me to appoint a lawyer for you, sir?
Please.
All right, Office of the Public Defender is appointed, and that's Division 15.
Your Honor, my information shows that Mr. Casino has no record, no prior arrest. Would the court consider releasing him on his own recognizance?
All right, State have any response?
See, there's no objection to a reduction. We would object to just a straight ROR, Your Honor.
All right, be released on your own recognizance with the following provision: do not return to the location where this allegedly occurred.
Yes.
All right, the next file I have is that of Jose Soto.
You refuse, Your Honor.
All right, reset. All right, Brian Richardson.
Yes.
All right, sir, you've got a case here. Just a second. Possession of controlled substance, cocaine, and paraphernalia.
No.
Your bond is $500 in regard to the paraphernalia case. Do you want me to appoint a lawyer for you, sir?
Yes.
Office of the Public Defender is appointed. Says here Division CRA.
He's out on bond, Your Honor?
Your Honor, this is also a pleable offense. I don't know if the state has an offer for Mr. Richardson.
Adjudication, 3 days.
Say again?
Adjudication, 3 days, Your Honor.
All right.
Your Honor, is the court inclined to take any action on the out on bond case?
Let me see. That's a ROR was initially granted. That would remain the same. That would be stayed, and the new case, bond 500.
Your Honor, the state has made Mr. Richardson a 3-day offer. He's going to accept that offer to resolve the possession of drug paraphernalia case for which he's here today.
All right, the state?
Yes, Your Honor.
Any input from the state?
The offer I made was adjudication, 3 days, Your Honor, on the possession of drug paraphernalia, 19 MM 3469.
Okay. All right, now, Mr. Richardson, do you
Yes, sir.
understand, sir, if you accept this offer, then you would be adjudicated guilty, sentenced to 3 days, with credit for 3 days, time served.
Thank you.
So you understand that?
Yes, sir, I do.
And you'd be giving up your right to a trial forever.
Yes, sir, I do.
All right, then the plea is accepted. There's an adjudication, 3 days, credit for 3 days, time served. And court costs of $323 payable within a year. All right, the next file I have is that of Gerardo Rodriguez.
Yes, sir. Good morning, sir.
All right, sir. Sir, you've got some failure to appear issues, it would appear. Yes, on burglary and theft matters, so the judge put you in a no bond status at this time. Sir, do you want me to appoint a lawyer for you?
Your Honor, I believe we already represent him. No?
Say again?
I thought we already represented him. We don't represent you? Let me check.
He has another case.
All right, there's a failure to appear capias, no bond.
I was mistaken, Your Honor. We don't represent him, so if he wishes, he may elect to be represented by my office today.
All right. All right, the next file I have is that of George Maxwell Jr.
Your Honor, Mr. Maxwell will be here to change his previously entered plea of not guilty and accept the city's offer to resolve his case today. The agreed-upon disposition is a withhold of adjudication, credit for time served, standard court cost of $223. I don't believe there was a cost of investigation. There was an email that was circulated yesterday, and
It's $223 court cost and a $10 filing fee.
and $10 filing fee.
All right.
Gotta get that filing fee. You doing all right, Mr. Maxwell?
Your Honor, I did get an email from the city confirming that that's the offer.
All right. Then there would be an adjudication, 10 days in the Orange County Jail, credit for 10 days, time served, and court cost, $223 payable within a year. So, sir, you do understand now that you are giving up your right to a trial,
Yes, sir.
all right? Then the order is hereby confirmed and that penalty imposed.
Yes, sir.
All right, the next file I have is that of Algernon Baker. Is that you, sir? Your name?
Yes, sir. Algernon Baker.
All right. All right, sir, you have a couple of matters here. A new case, petty theft of 2 prior convictions, and you are out on bond on a grand theft and resisting case. That bond is stayed. However, the new bond, instead of $1,000, would be $2,500 since you are out on bond and that that bond is not being revoked. Do you want me to appoint a lawyer for you, sir?
Yes, sir.
Public defender is appointed, Division 15.
Your Honor, may I have a brief moment before we dismiss Mr. Baker? He has a county matter. I don't know if the jail could speak to what that might be about, or Manatee County? Okay. Good luck, sir. Thank you. Mr. Black.
Next case I have here is that of Clint Bartz.
He refused, Your Honor.
All right, reset. Antonio Bell.
He's behavior.
All right, reset. All right, next case is that of Horace Black. Is that you, sir?
Yes, sir.
All right, sir, you've got a case here. Well, it looks like a couple of matters. New case here involving a charge of robbery. Bond on that case is $2,500. And then another case involving grand theft, third degree, more than 300, less than $5,000. And conspiracy to commit grand theft. Now, sir, do you want me to appoint a lawyer for you on these matters?
I'm going to get a public defender.
Public defenders are lawyers.
Oh,
All right, so the Office of the Public Defender is appointed. The bond on which you're previously released is stayed. And let's see, we got Division 19. And 12, it looks like. Yes.
Your Honor. We have future warrants.
All right. Come on up. Just a second.
Good morning, sir.
Good morning.
The top ones are waivers of extradition.
Okay.
There's 2 pages of those. There's a one behind it.
Oh,
The top ones are 2 pages, but there's one that you'll have to sign, that's 3.
okay. not the same
No,
individual?
it's not the same.
Okay.
This guy here. I have on this one, right there, the no bond, and then there's a third page.
Manny. No Acevedo? No objection to RR.
No, it should just be a single page, they refused it.
That's the first one.
Okay.
Acevedo, Vega, Andres.
Yeah.
No objection.
All right, the next file I have here is Norfolina Cabrera.
Thank you.
Your name, sir?
John Clifton Cooks.
All right. All right, now, you are John Cooks?
Yes, sir.
All right, sir. You have a new case involving possession of cocaine with intent to sell. Bond is $10,000. You are presently out on bond. And those bonds at this time would be stayed, and your new case does involve that $10,000 bond. You want me to appoint a lawyer for you, sir?
Yes, sir.
Public Defender appointed, Division 12.
Judge Harris.
All right, Danny Dawson.
Hold on one second.
All right, sir, you have a couple of matters here. Failure to appear on a case. The judge set you in a no bond status. That's failure to appear for a case management conference on April the 17th. And there's one other matter, it would appear. Yes, a new case involving possession of cannabis, bond $100, resisting an officer without violence, bond $500. Now, sir, do you want me to appoint a lawyer for you?
Yes. Yes, sir.
All right, Division 22 on the FDA and Division A on the cannabis and resisting case.
$1,000? Okay. That's what I thought.
All right, the next file I have is that of Virgil Foggy.
It's not John.
All right, sir, your name, please?
Virgil Fogey.
All right, sir, you've got a case here involving driving while license suspended with 2 prior convictions. Your bond was set at $2,500. Do you want me to appoint a lawyer for you, sir?
Yes.
Public defender's appointed, that's Division 20.
And he does qualify for PTR, Your Honor.
All right, so ordered. Okay.
What's his purge? Oh, purge out.
All right, next file is that of Cornelius Gist, or Gist.
Yeah, Cornelius Gist.
All right, sir, you've got a case here involving driving while license suspended with 2 prior convictions. Your bond at this time is $2,500.
And he also qualified for PTR, Your Honor.
Let me look.
That's on both cases.
Yes.
And you've got a cannabis case on $250.
Judge, the defendant qualifies for pretrial release on both cases. State has no objection.
All right, then PTR, we've got Divisions 10 and Division 8.
Did you appoint a public defender for him? He didn't fill out a form. Did you appoint him?
Did he
Oh,
fill
no,
out?
I agree with you, but,
No? All right, he's failed to fill out the financial aspects of,
hold on one second.
at this time, the Office of the Public Defender is not appointed.
That was from Mr. Gist?
Yes.
Okay.
Unless the public defender's already representing him on something,
No, I don't believe we are.
all right? All right, the next file is that of Patrick Gray. All right, are you Mr. Gray?
Yes, sir.
All right, Mr. Gray, sir, you didn't complete the financial affidavit. So, what is your take-home pay every 2 weeks?
Oh,
You gonna hire your own lawyer? Oh, okay, go ahead, I'm sorry.
the job we have just started is, we had just started a new business over there off of, Westmoreland. It's a mattress service business, and, we haven't discovered the payment plans yet, so we're just paying, he's just paying us under the table for right now.
All right, well, in an abundance of caution, I'll go ahead and appoint the Office of the Public Defender, and that's Division 10. All right,
Mr.
the next file is that of
I'm sorry, Your Honor,
Martha-
before we dismiss Mr. Gray was telling me that he does not have the financial resources with which to pay the bond set by the court. He was hoping the court would consider lowering the bond. He was telling me that he has $25 in cash that he hopes to use
All
toward his
right,
bond.
state's response, if any?
No objection to a $500 bond, Your Honor.
All right, $500 it is.
I'm sorry.
Then Martha Green,
That's gonna be it today. Sorry. That's gonna be $100.
your name, ma'am?
Martha Green.
All right. Ms. Green, you've got a total of 4 charges here at this point in time. Trafficking in phenolphthalein, 20 grams or more, bond 100,000. Possession of controlled substance without a prescription, bond 1,000. Possession of methamphetamine with intent to sell or deliver, that's $50,000. And possession of drug paraphernalia, bond $500. Do you want me to appoint a lawyer for you?
Yes, sir.
All right, Office of the Public Defender is hereby appointed, Division 19.
Your Honor, the defense was hoping the court would consider lowering the bonds in count number 1 and count number 3. With respect to count number 3, the information in the incident report states, and I believe it's towards the bottom of the 3rd paragraph, the last sentence, that law enforcement believes that the drugs weigh more than 10 grams. Drugs were never weighed. So I would ask the court, if nothing else, to drastically lower the bond on count number 1.
All right, state's response.
State can request 24 hours, Your Honor, in order to ask the officer if they weighed the drugs. If not, if the defense would like to stipulate, I have no objection to treating counts 2 through 4 as subsidiaries and putting the bonds at 150 and leaving count 1 at 100,000.
All right, so ordered.
I'm sorry, which part of that, Your Honor?
The part in regard to count 3.
Your Honor, the state's suggestion was leaving count 1 at $100,000 and lowering the bonds on counts 2, 3, and 4 to $150.
Yes. And that's Division 19. All right, Andrew Harrison.
Yes, sir, Your Honor.
Sir, you've got a case involving aggravated assault with a deadly weapon. Bond is $2,500, and I'm also adding a provision that you would have no victim contact in regard to this case. Sir, do you want me to appoint a lawyer for you?
Yes, sir.
Public defender is appointed, and that's Division 20.
State would also ask for no weapons or firearms, Your Honor.
All right, that would be included also, the weapons or firearms. All right, Heather Hensey.
Yes, Your Honor.
Ma'am, you've got a failure to appear capious on 2 charges, it appears. Possession of methamphetamine and paraphernalia. Do you already have a lawyer appointed for you?
Bradley Boland.
She's represented by my office,
Yeah.
Your Honor.
All right.
By Mr. Bowling.
Then that appointment would remain, and that is Division 12. All right, the next file I have is that of Jason Hollenden. Is that you, sir?
Yes, sir.
All right, sir, you've got a case here involving driving while license suspended or revoked, bond set at $2,500 in regard to that. Now, sir, do you want me to appoint a lawyer for you?
I'm represented by the public defender.
All right, public defender is hereby appointed, and
He does qualify for PTR, Your Honor.
No objection.
Your Honor, he has, I believe this is his first arrest. Would the court consider releasing him on his own recognizance?
no, the bond would be reduced to $1,000, and that's Division 15.
Well, Your Honor, in the alternative, he qualifies for release of PTR. Would the court consider release to PTR as the conditions of release?
Under the facts alleged, the court's ruling would stand.
Okay, thank you.
All right,
We're going to talk about it in a second.
Michael Hook, or Hooks.
Yes, sir.
Sir, you've got, let's see. A new case here involving sale, delivery of cocaine. Bond is $10,000. Let's see. Now, you've got a slew of charges here. Looks like 80 charges of possession of ammunition by a convicted felon.
Your Honor, there was a few arguments the defense wanted to offer on behalf of Mr. Hooks. Whenever you've had after, of course, you've had a chance to review the incident report, starting with the multiple counts of possession of ammunition by a convicted felon. I think Madam State will agree that possession of ammunition is charged as a single offense unless there's different type of ammunition. I believe in this instance it was only bullets. Ammunition is treated as a mass noun, so we wouldn't charge for each individual bullet.
All right, now, there was an order signed by a judge, and it said that that the total bond is $10,000 as opposed to, all right, here we go. Armed possession of heroin with intent to sell, bond $10,000. Possession of heroin more than 10 grams, bond $10,000 for a total of $20,000. Then it looks like, and public defender have a prior representation.
Aren't we here on
There's
other
no
charges?
affidavit.
Have you previously represented him?
Do we represent you on the other case? Yesterday, were we appointed?
Wasn't nobody appointed. I bonded out.
Huh?
That's what I'm saying. I bonded out, and then I got hit with a bunch of other charges.
This question is, do you guys represent him already?
No, he bonded out prior to coming to initial appearance, Your Honor. So he has no representation from my office, at least
All
to
right.
my knowledge.
That's Division 10, if I didn't previously announce it.
You only bonded on the one case. With the one count, and the bond on the other case.
Your Honor, in order to make, since it's the number of counts, State has no objection to $500,000 on count 1, leaving all other counts as subsidiaries as $150. And except for all of the possession of ammunition by a convicted felon, on one of those do $150 and all others do an ROR.
All right.
Mr. Soto Diaz. Does that work for you?
Yes,
Thank you.
that'll work.
Now, there is no application for criminal indigent status filed. Does the Office of the Public Defender know if you've had priors?
I'm sorry, Your Honor.
Have you previously represented Mr. Hooks?
No, he's always had a private attorney.
Okay. All right. Then apparently that's it.
Nagy, the warrant, the other case, that was one count, $10,000? Okay. And these are the other charges. All right, good luck.
All right, Kevin McCall?
Yes, sir.
All right, so you've got a case here involving retail theft. Bond is set at $1,000, and then there's another identical allegation, retail theft, more than $300, bond $1,000. And there's a third charge, retail theft, bond $1,000. Do you want me to appoint a lawyer for you, sir?
I got a public defender, I guess. Public defender.
All right, you qualify, so the Office of the Public Defender would be appointed. We have Division 11, Division 16, and Division 20. All right, next file is that of Thomas Herrero.
Yes, Your Honor.
All right, sir. Mr. Marrero, you've got a charge here, possession of cocaine. Your bond is set at $1,000. Now, you filed an application for criminal indigent status. However, if I understand this correctly, it says you make $15 an hour. Is that correct?
I just started the job.
Well, how many hours would you normally work?
I literally just started yesterday. So I
Well,
didn't even work.
if you go back to work, do you know how many hours you would work?
It's part-time.
How many?
It's part-time, under 20 hours.
Say again?
He will qualify.
All right, Office of the Public Defender would be appointed in regard to this case. That is Division 14.
And he does qualify for PTR, Your Honor.
All right, PTR would be allowed. Christopher May.
Yes, sir.
All right, sir. Sir, you've got a CAPIS that was issued here, dealing in stolen property, bond $5,000, receiving money from a pawnbroker by false verification of ownership, bond $1,000. Let's see if that's... No. With conditions, no contact directly or indirectly with the victim or co-defendant or a witness, and do not return to the scene of this offense at 140 West Myrtle Street in Apopka. Now, sir, do you want me to appoint a lawyer for you?
Would that be free of charge, or would the $50 public defender?
You would be appointed, if you wish to, by the Office of the Public Defender, who are all lawyers.
Yes, Your Honor, I would like
All right,
to be
Division
appointed.
16. All right, next file is that of Wilfredo Nazario Jr.
Your Honor, we'll waive the reading of the charges.
Say again?
We'll waive the reading of the charges.
All right. All right, on the second Division 15 case, there's a no bond status at this time. And in regard to the drug type matters, there's a total of $1,100. Now, sir, do you want me to appoint a lawyer for you?
Yes.
Public defender is appointed, and that is, looks like Division 15 on each case.
Your Honor, the first set of charges that you referenced in Division 15 are bondable cases. They come in no bond because of the bail bond schedule.
Well, let's
There's
see.
second-degree felonies.
All right, what's the state's input in regard to that?
Your Honor, I do agree with defense that they have the potential to be bondable offenses. However, state would argue that the defendant should be held at no bond based on 907.041. We believe that these two charges are dangerous crimes under that statute. They're number 14 under that statute. We also believe that based on the nature of the offense, how this was committed, that there were it was a 12-year-old and a 13-year-old girl that this happened in front of, that he was driving a vehicle in a neighborhood, an apartment complex, and the fact that without revealing the type of charges, what he was doing or his conduct. We believe that the court should conclude that there are no reasonable circumstances sufficient to provide protection to the community, and the risk of harm to other minor children is high, that the defendant should be held at no bond, that he should have no contact with any minor children. The police were able to identify him based on investigative means, based on the description that the children gave of the car that the defendant was driving. And I believe the court would have had access to the affidavit of arrest warrant to see what the children described his behavior was.
All right.
Your
now,
Honor, Florida Rule of Criminal Procedure 3.132 outlines the state's burden with respect to a request for pretrial detention. To the best of my knowledge, a motion has been filed. So this court would have no option
Well-
but to set conditions of release.
For purposes of this hearing and without prejudice, the bond in regard to lewd, lascivious, et cetera, would remain at none. And that, as I say, is without prejudice. And we have, Division 15 on each.
Thank you, Your Honor.
All right, the next file is that of Luis Pagan or Ortiz. What is your name, sir?
Louis Antonio Pagan, sir.
All right, sir. Now, sir, you've got a couple of issues here. You are out presently on bond in regard to robbery, battery on a law enforcement officer. And so what is going to happen now on the new case, first of all, the bond on the case on which you were released would be stayed. However, that being the situation, burglary of a conveyance bond would be increased on the new case to $5,000, and then the other two $100 bonds would be stayed. And sir, do you want me to appoint a lawyer for you?
Yes, public defender.
All right, Office of the Public Defender is appointed. That's Division 16.
I'll see you there. Right. Yo, hold on. Let's have you just a second.
All right, your name, sir?
Mateen Caduce.
All right, sir, you've got a failure to appear capious, no bond status in regard to a case involving a charge of grand theft of a firearm, and that you failed to appear on April the 12th of this year. Sir, do you already have a lawyer that was appointed on this case?
Was Nick James? Was
Sir?
it's Michael LaFay.
Ah, all right. Then I am assuming you wish to maintain Mr. LaFay, is that correct?
I would have to speak with LaFay and my mother to see what we would do, because
Well, sir, at this time, is Mr. LaFay representing you?
he doesn't know about anything, so no, he is not representing
All
me.
right, then in an abundance of caution, I think it appropriate to go ahead and appoint the Office of the Public Defender, and the Office of the Public Defender can withdraw if that's indicated. And let's see, we've got,
Hold on 1 second. I'll take this. Your Honor, Mr. Caduce currently participates in the Orange County Drug Court program. He was here because he was facing a 5-day sanction. He must have failed to appear for that sanction, and I know personally, because I used to practice before the judge, that the judge would issue a failure to appear warrant. He'll likely be seen by the judge in the next few days. But this isn't a new case, I guess is what I'm trying to get at. He's participating in one of our specialty court system.
all right, what's the state's position in regard to this?
Your Honor, we're state's gonna ask that it be held at no bond. I'm looking at, there have been a couple of violations of his probation, probably of drug court, which got him into drug court. So at this point, we think Judge Whitehead is probably best suited to make a decision on whether or not he should get conditions of release.
Yeah, no, I'm sorry. I'm not asking for conditions of release. I just don't think that he needs the appointment of the public defender's office right now.
Okay.
All right,
One case, he doesn't have an attorney at all. You only have LaFay on one case. He has 2 failure to appear.
Okay, well, that's different then.
So the 2018 CF 11547 case doesn't have an attorney?
11547, he has LaFay.
You're on probation, right? 3 years
You don't
probation.
have no attorney.
Yeah.
all right, well, in an abundance of caution then, in regard to that 16056 case, the Office of the Public Defender would be appointed, and certainly Mr. LaFay can seek to, or rather, the defendant may seek to have Mr. LaFay on that case also if he wishes. But I want to make sure he has a lawyer at this time. All right, next file is that of Rodolfo Rivera Jr.
Yes.
All right, sir, you have a case involving allegations of possession of cocaine, bond $1,000, possession of methamphetamine, bond $150. Probable cause does exist. Now, sir, do you want me to appoint a lawyer for you?
Yes.
All right, Office of the Public Defender would be appointed, and that's Division 22.
And he does qualify for PTR, Your Honor.
No objection, Your Honor.
So ordered. All right, Delray Robinson.
East Downtown Port, Your Honor.
All right, reset. All right, Boris Rodriguez Camejo. Is that you, sir?
Yes.
All right, sir, you've got a set of charges here. Possession of 3.4 grams of methamphetamine, bond $1,000. Possession of controlled substance, bond $150. And let me look further. Oh, there's an out-of-county warrant out of Dade County down in Miami, and that's a $20,000 bond, which can actually be posted here, but if not, you'll be transported to Miami to answer to the charges there. Now, as to the case we have here, does the Office of the Public Defender have prior representation?
I don't have any personal knowledge, Your Honor.
I don't have any application for criminal indigent status. So do the other judges then, if they don't fill out the application, do they not appoint them or appoint them? You say no? Oh, okay. Well, in an abundance of caution here, I'm going to provisionally appoint the Office of the Public Defender. That's Division 10.
Come on up, buddy.
All right, let's see. Next case is that of Troy Sparrow.
How you
Is that
doing, Your
you,
Honor?
sir?
Yes.
All right, Mr. Sparrow, sir, you've got a charge of first-degree murder with a firearm. You're in a no bond status at this time. Do you want me to appoint a lawyer to represent you, sir?
I will be obtaining a lawyer, Your Honor.
You what?
I will be getting me a lawyer.
He's hiring private counsel, Your Honor.
All right. Okay,
So
then
did she
that's
file
it for the
in
moment.
Did she file it in a way? You know?
All right, Brandon Thomas.
Yes, sir.
All right, sir, you've got a charge of retail theft. The bond is $2,000 in regard to that. Do you want me to appoint a lawyer for you, sir?
Yes, sir. I was shopping. I didn't do anything.
Well, don't say anything about
They
the
don't have any
facts of the
proof.
case. But
Yes.
if you want, we're talking lawyer only, and you indicated yes, and you qualify according to your application here. So
Yes, sir.
public defenders appointed, Division 10.
Is it possible I get released today, Judge?
Say,
Is it possible I could get released today on my reconnaissance?
I can't understand.
Can we get an oral
Oh. Let me see the,
He has 6 failures to appear, Your Honor, with the last one occurring in July of 2017. State would object to an ROR.
well, with that situation then, the defense request would be denied without prejudice.
You got the wrong Brandon Thomas. I've never been in Florida before this year.
All right.
I'm not even on probation.
All right, next file is that of Desmond Walsh. Is that you, sir?
Yes, sir. Yes, Your Honor.
All right, sir. You've got a set of charges here. Possession of cannabis, bond 100. Possession of cocaine, bond 150. Possession of paraphernalia, bond 100. Possession of ammunition by a convicted felon, bond $5,000. And you're out on bonds at this time, and those bonds on which you're released are stayed at this time. And, sir, do you want me to, well, I haven't got the request for appointment of counsel. So, you can always request appointment of a lawyer. I just don't have a request by you at this time. That's Division 12, and that's all for the moment. Okay. Let's see.
I think so. We're done? Okay.
Hmm? Okay.
Your Honor, may I have a brief moment? May I have a
Yes.
brief moment? Thank you.
right, now in this next case, I don't have the application for criminal indigent status.
What's the name on that case, Your Honor?
Marlon Williams?
He's a possibility of being an interpreter case. We're not sure yet.
Oh,
Can we just have him reset, please?
all right. So ordered. All right, next file I have is that of Michael Emery.
East TOT to Osceola County.
All right.
He is? Okay.
Charles White.
Yes, sir.
All right, so you've got an Osceola County case, and your bond was set in that county at $2,500. So you can post it here. Let me check the case numbers here. Yeah. All right, you can post it here, or to be transported to Osceola County, and you can post the bond there, or you don't have to if you don't want to. But no lawyer is appointed at this time, in that we're in Orange County. And if one is appointed, it would be in Osceola County. All right, Jonah Harris?
Yes.
All right, sir. You've got, looks like a set of charges, and there was originally some different bonds, or lack thereof. Now,
Your Honor, may I approach?
yes,
The case that's reset for probable cause from the state.
oh, all right.
It's 3 cases. It's Brandon Lee Myers, Demetrius Patrick, and Jonah Harris. There are 3 co-defendant cases. Your Honor, I did provide a copy to the Office of the Public Defender this morning. I believe the judge found no PC to all 3 of the defendants as to counts 1 and 2. So for Mr. Harris, who's present before you, I have no PC to count 1 and 2, PC for count 3, no PC for counts 4, 5, and 6. Based on the affidavit that state has just provided to the court, the victim identifies Mr. Harris along with his along with his co-defendants as the ones that he was chasing, and that one of them fired the weapon in his direction, firearm in his direction. They were able to do a show up after the 3 co-defendants were caught by law enforcement shortly after. The show up was conducted, and therefore they identified these 3 defendants. 2 of the defendants had a weapon on them. I believe Mr. Harris was one of, yes, he had a .40 caliber Smith & Wesson that was found on him at the time of his stop.
Your Honor, that all may be true, but the information that the state provided is not an affidavit form, and none of it should be considered by this court when determining whether there's probable cause for his detention or any of the other co-defendants. And that's the objection that the defense would have for, in his case, and the subsequent cases that we'll likely hear shortly.
All right, and the state's response?
Is Your Honor, yesterday, Ms. Bush, the Assistant State Attorney and President Court, she did reach out to the deputies. These are the reports that were given to us by the Orange County Sheriff's Office Records Department, where the officers submitted all of their reports for this particular incident in this case.
Oh,
Your Honor, I don't see a signature. I don't see the jurat. It's not notarized. It's not an affidavit.
All right, and the state's response to the defense argument and statement?
Your Honor, the supplemental reports are the ones, this is what law enforcement provided state. State would, if Your Honor is not going to find PC based on the supplemental reports, state can ask for 24 additional hours. However, state believes this is sufficient at this point with the original affidavit along with the supplemental incident reports provided by, I believe one of the reports is from Deputy Lozano and one is, it looks like a Darko Stamenic.
You know, the state is not entitled to an additional 24 hours. There's nothing extraordinary about failing to provide an affidavit when you're asked to, especially when we're talking about somebody's detention. It's a rather routine matter.
Your Honor, when I to take Your Honor back to the original report of Deputy Lozano's report, he does identify this co-defendant Jonas Harris and the other two as the ones that opened fire on him as he was chasing them when he tried to deploy his taser. He identifies them in that original report as well.
All right, at this time, and having considered the incident report that was not signed, however, it appears to go along with this other. Anyway, in regard to this, the count one assault with a firearm would be set at $7,500. Possession of a firearm in conviction of a felony, bond $2,500 from $150. Attempted armed burglary of a conveyance, instead of no bond, it would be $150. Carrying a concealed firearm, bond $150. Possessing cannabis with intent to sell or deliver, bond $150. And resisting without violence, bond $100.
Your Honor, state would also ask for no contact with the victim, no return to the scene, no weapons and firearms, and no contact with the co-defendants.
All right, that would be ordered. It appears customary in regard to this type of situation. All right, the next case is that of Bradley James Myers. Is that you, sir?
Yes.
All right, Mr. Myers.
Your Honor,
We
this
have
is the
a-
companion case to the case we just addressed.
Say again?
This is a companion case.
It was 3 co-defendants. This is the second co-defendant, Your Honor.
The defense would maintain the same objection that it levied in the prior case.
State would have the same responses, Your Honor.
Well, the judge signed an order well, that was as to probable cause.
It's the same probable cause affidavit, Your Honor, that I gave you in the last case. Based on my notes from Ms. Bush yesterday, I have a $3,500 bond as to count 3 where PC was found. State would argue that there should be PC for counts 1 and 2, and I have a $1,000 bond as to each of those counts on my notes from yesterday. State would ask for no contact with the victim, no return, no weapons and firearms, and no contact with the co-defendants.
All right. Judge, looks like Judge Carter signed this order. Ag assault with a firearm, bond 1,000. Use of firearm with commission of a felony, bond 1,000. Attempted armed burglary of a conveyance, bond $3,500.
And there was no contact with the victim, no return, no weapons, no firearms, and no contact with the co-defendants?
So ordered. So
Thank you, Your
ordered.
Honor.
All right, next file I have is that of Demetrius Patrick.
And Your Honor, this is the third co-defendant of this string of cases. So my notes show that PC was found as to count 3 and a $5,000 bond as to counts 1 and 2, $150 as to each of those counts. We would ask for no contact with the victim, no return, no weapons and firearms, and no contact with the co-defendants.
Your Honor, and the defense would maintain its previous two objections. The information provided by the state is not an affidavit form and shouldn't be considered by the court.
Justice system.
All right, anything further by the defense?
No, Your Honor, thank you.
We got a city.
All right, now, we've had a lot of time devoted to this hearing. Anything further from the state now?
No, Your Honor.
All right. I feel then that at this time, there is probable cause and the bonds are set as ordered by Judge Carter. 150 on counts 1 and 2, 5,000 on count 3, with no victim contact, possess no weapons or firearms.
And no contact with co-defendants, Your Honor?
Say again?
And no contact with the co-defendants?
Yeah, yes, so ordered.
Thank you.
All right, next file I have,
You one of our bond motions? Oh, that's right, I'm sorry. I had you mixed up with somebody else.
is that of Davin Vega?
It is, Your Honor, he's standing to my right.
All right, any offer from the state?
Adjudication credit for time served, Your Honor.
Adjudication what?
Credit for time served.
Okay.
Nice job.
And what are, Now, Mr. Vega, do you understand that you would be giving up your right to have a trial if we go forward with this?
He understands, Your Honor.
All right, then there would be an adjudication. And, let's see. time served, let's see, 3 days, and you said $223 in court costs assessed payable within 1 year. And we have an extra.
Your Honor?
All right, next case I have is that, well, let's see. Got 2 cases here. One is Andres Acevedo Vega, and the other is Brandon Tasquan Daniels.
On Mr. Acevedo Vega, state has no objection to granting of the ROR on this case. I mean, you have second session?
All right, so ordered then.
Your Honor, do you have a proposed order?
Do you have a copy of the proposed order? Okay.
No, that's not.
Yes, I have one, sorry.
Thank you.
Halfway through.
All right, then I have 2 other files here, or motions. Brandon Daniels.
Your Honor, Mr. Daniels' case, state has no objection to granting of the ROR.
All right, so ordered.
The next motion the court should have is a 33-day motion on Jamel Walker. It's a private attorney's case.
All right, that's case ending number 3093, Jermel Walker.
That should be granted. The state has not made a charging decision in Mr. Walker's case.
Okay.
And the state is ready to proceed on 33-day motions, Your Honor.
All right, first case I have is last name Longo, case ending in number 4216.
That should be denied. The state filed an information on 4/25, filing ID 88514085.
So ordered. All right, next case, defendant name ends in Beluso, case ending in number 211.
That should be granted. The state filed a notice of non-filing before the 33rd day on 4/24.
All right, so ordered.
Manny, do you want
All
to
right,
see this transfer?
Next case ends, name ends in number, let's see, Resto Garcia, case ending in number 2585.
That should be denied. The state filed an information and a request to transfer from felony to misdemeanor this morning. I can show a copy to the public defender's
All
office.
right, so ordered, denied.
It's not email.
Joe Nathan Brewer, case ending in number 3131.
That should be denied. The state filed an information on 4/25, ID 88548970.
So ordered. Kevin Davis, case ending in number 4219.
That should be granted. The state filed a no information notice on 4/25.
So ordered. All right, Stephen Garrison, case ending number 4037.
That should be denied. The state filed an information on 425, excuse me, ID number 88549-680.
All right,
I'm sorry, Your Honor, that's Stephen Garrison?
Yes.
all right, Will Black Vernelius, case ending number 2760.
That should be granted. The state filed a no information notice on 425.
So ordered. All right, well, took sort of long this morning.
here's the
How long did council request
Of the-
to take a break for the court?
How long do you need, Mr. Soto Diaz?
Let's say 15, 20 minutes.
Okay, we'll go with 20. Court's in recess for 20 minutes. All right, once again, if council please announce their names for the record.
Coffee Kennedy Swanson on behalf of the Office of the State Attorney.
Cody Jordan on behalf of the Public Defender's Office.
And Manuel Soto Diaz with the Office of the Public Defender.
Thank you. All right, the first case I have is that of Jacavius King. Is that your name, sir?
Jacavius King.
All right, sir, you've got a case here involving driving while licensed suspended as habitual offender. Your bond is $2,500 at this time. Do you want me to appoint a lawyer for you, sir?
Yes, sir.
All right, public defender is appointed. That's Division 15. All right, Lindsay Kosh.
Can we pass by Ms. Cox's form, Your Honor?
All right. All right, Dwayne Long.
Dwayne Long is behavior.
All right, reset. Gene Mullis.
Yes.
Is that you, sir?
Yes, sir.
All right, sir, you've got a charge here, burglary of an unoccupied structure, bond $3,500, and trespassing on school grounds, bond $100. Do you want me to appoint a lawyer for you, sir?
Yes.
Public defender is appointed, Division 14. All right, Johnny Perez.
Yes, sir.
All right, Mr. Perez, sir, you've got a case here involving an allegation of violation of drug probation. And in regard to this, do you want me to appoint a lawyer for you, sir?
Yes.
You
Yes,
said-
Your Honor.
All right, public defender is appointed, Division 17. All right, James Rogers.
Behavior, Your Honor.
All right, reset. Next case is that of Efrain Uribe Valdez.
Yes.
All right, sir, you've got a set of charges here. Burglary of an unoccupied structure, bond $3,500, and trespassing on school grounds, bond $100. Do you want me to appoint a lawyer for you, sir?
Yes.
All right, Office of the Public Defender is appointed at this time. That's Division 11.
Your Honor, he has no priors. We would ask, given that he has no priors and this is his first charges he's ever received, if he could be released on his own recognizance.
State would object, Your Honor. It looks like he has previously been arrested for similar type offenses. If you give me one moment, I can see if those are Orange County cases.
Well, count one, there would be a reduction down to $2,500. I don't know if that's significant, but that's the order of the court at this time. And this is Division 11, Public Defenders appointed.
Your Honor, we'd ask for no return to the school.
And yes, no return to that school that's involved here. All right, Vincent Whitmore.
Yes, sir.
All right, sir. Sir, you've got a charge of driving while license is revoked as an habitual offender. Your bond at this time is $2,500. Do you want me to appoint a lawyer for you, sir?
Yes, sir.
All right, public defender's
Your
appointed.
Honor, state has no objection to pretrial release for this defendant.
All right, then that would be allowed. Division 19. All right, Brenda Cox. Your name, please?
Brenda Cox.
All right, Ms. Cox,
Aye.
you have a capias issued for failure to appear. Your bond was set at $2,000, failure to appear for a pretrial court hearing. Now, all right, public defender has been previously appointed, I'm told. That's Division 84.
State has conveyed an offer, Your Honor, of a withhold of adjudication, credit for time served, and an anger management class within 60 days of her release.
What would the court cost be?
Your Honor, I've had time to speak to my client. She's willing to take that offer.
All right. Now, ma'am, you are entitled to have a hearing, and you're also entitled to enter this plea on that basis. So, do you want to go ahead and admit that you did fail to appear in regard to the case, and that was involving a charge of possession of cannabis? So is that what you want to do?
Your Honor, I believe she does want to contest this.
Say,
She wishes to contest the,
all right, that's fine. Ma'am, do you want me to appoint a lawyer for you? Oh, already has one, I'm told. And, let's see, that's Division 84.
Your Honor, I'm sorry, she does wish to take it. She simply wishes to express to the court why she missed the court date.
I missed the court date because I was called twice that morning from the public defender's office and told, do not come to court at 1 o'clock. And I did not show up. Otherwise, I would have been here, Your Honor.
All right. Well, there was some misunderstanding apparently, so adjudication would be withheld, so you're not adjudicated guilty of this. You'd be sentenced to, looks like 2 days, credit for 2 days time served. And I'm not going to require the anger management course under these circumstances. Court costs would be $323 payable within 1 year. So, ma'am, do you understand you're giving up your right to have a trial? Do you understand you're giving up your right to have a trial?
Yes, sir.
All right. Rafael Martinez?
Yes, sir.
Sir, you've got a charge of driving under the influence with 1 prior conviction. Your bond at this time is $1,000. Do you want me to appoint a lawyer for you?
No, thank you.
Your Honor, the offer from the state is an adjudication of guilt, credit for time served. This is on
And he
Mr.
does qualify for PTR as well.
This is Ms. Rodriguez, you said?
No, it's Martinez.
Okay, that's not the right case, Your Honor. I apologize. No objection to PTR.
All right. Then that would be so ordered. Public Defender appointed, Division A. Next cases are those of Carly Williams. All right. Maria Galarza. Is that you, ma'am?
Yes, sir.
All right, you have a case here involving possession of drug paraphernalia. Your bond at this time is $500. Do you want me to appoint a lawyer for you? Yes, no?
The offer from the state is an adjudication, credit for time served, Your Honor.
The offer is right now. Your Honor, she does wish to take the offer from the state.
All right, and court costs? $323, okay.
Your Honor, is
Ah.
the PD appointed?
Say again?
Is the PD appointed in this case?
Yes. All right, adjudication, 1 day, credit for 1 day, time served, court cost, $323 payable within 1 year. All right, next file is that of Juan Lopez.
His behavior, Your Honor.
Reset. All right, Larry Odom.
He refused.
All right, let's reset that one too. Timothy Owen.
Yes, sir.
Sir, you have a case here involving a charge of possession of drug paraphernalia. Now, you didn't complete the application for criminal indigent status. Your bond is $500.
The offer is an adjudication, credit for time served.
Your Honor, I have spoken with him. He does wish to take that offer.
And court costs. All right, so ma'am, you understand you'd be giving up your right to have a trial. Excuse me, sir. You understand you'd be giving up your right to have a trial if you do this.
Yes, sir.
All right, and so in regard to this, there would be an adjudication of guilt, 1 day, credit for 1 day, time served, court costs $273 payable within 1 year.
Yes, sir.
All right, next case is that of Willie Parker.
Yes, sir.
All right, sir, you've got a set of charges here: possession of drug paraphernalia, bond $1,000, and possession of marijuana, a small amount, bond $200. Now, you filled out the application for criminal indigent status. However, you do not qualify for appointment of the public defender. That being the case, let's see, I don't know that there's even an offer.
I didn't make an offer because he has no criminal history, but I have no objection to ROR on Mr. Parker.
All right, and ROR it is. All right, Joseph Van Pelt.
He's mental health, Your Honor.
All right, reset. All right, now, next case is that of Brittany Carmine.
Yes, sir.
Ma'am, you've got a Lake County warrant. Your bond was set in that Lake County case at $5,000. You can post that there or here, but if you don't bond out here, then you'll be transported to Lake County to answer to these charges of grand theft.
Okay, I don't have a hold here, right? Like, I'm not gonna be detained, I can be found out and it won't be held or nothing? Yes? Okay, thank you.
All right, Marlon Williams. Is that you, sir?
I'm Keith McCray.
Sir?
Williams was on first session.
Oh, okay.
It was reset on first session.
Was reset to this afternoon, or this second session?
Tomorrow, Your Honor.
Oh, all right. No action. All right, the next case is that of Keith McCray. Is that you, sir?
Yes, sir.
All right, sir, you've got an open container charge with the city, bond $250, offer from the state.
Adjudication of guilt, credit for time served, Your Honor.
Your Honor, he will take that offer.
Okay, court. Hmm? Yeah. All right, so sir, do you understand you're giving up your right to a trial if we go forward with this case as a plea?
I understand, sir.
All right, then the plea is accepted. There's factual basis. There would be an adjudication of guilt, 2 days credit for 2 days time served, $273 in court costs payable within 1 year.
Yes, sir.
And
he was
Now,
out on bond?
there was
Your Honor?
a,
He was out on bond? Are you taking any action on that?
he was
2019 CF 5747 AO?
Oh, that is stayed.
Okay,
Thank you.
thank you, Your Honor.
All right, now, then there was a case from the first, maybe the first case called, I don't know. Anyway, Lindsay Kosh,
She's gonna be mental health, Your Honor.
all right, reset. Well, regrettably, I have no further files. So I guess we will adjourn. Court's in recess, subject call.